May I please? Your Lordship?
Yes, please.
So I beg to mention item number 3 to 4, my lord, with due consent of other parties, my lord. In this case, my lord, Justice Ukener was appeared for some of the private respondent, my lord.
Oh.
So I informed the respondent, my lord, for this development. Lordship, I may be matter may be adjourned for some days, my lord.
Okay.
Some affidavit was required to be passed. No, for amendment like post title.
No.
Item 4.
3 to 5.
Item 4 is Papuri Gogoi.
Yes.
Last one, of course, there is some requirement of filing amended post title.
That is up to appellant, my lord.
You check up. You're
I'm for the respondent, my lord.
okay.
Respondent.
Respondent 1 and 2.
Have you taken the consent of
Lordship,
the
I inform other
petitioner's
segment.
counsel?
Lordship,
Okay. On request made by Mr.
M. Mohan Tamil.
M. Mohandal and account for respond number 1.
1 and 2 million.
1 and 2. List the matter after.
In the month of February, because part of the KNC, senior for KNC was also there, my lord.
5th February.
Lordship, if possible, not after 15 million.
After 15 you are. 19th.
Lordship.
19.
Yeah.
Lordship, fixed it is on 19th of January.
February.
19th of February. All that.
Lordship, may I pray for the listing of 2 writ appeals, your Lordship, for admission day after
In these
tomorrow?
2 cases, I am appealing for the state respondent.
Okay.
Yeah, there was some confusion. He said he's for the state respondent. I am appealing for the state respondent.
State respondent.
Mine.
Okay.
In item
Mr.
3,
D.
4, and 5.
Majumdar and additional AG. Assam appears on behalf of the state respondent.
May I pray for the listing of 2 writ appeals for admission day after tomorrow? Lordship, the urgency is that earlier, when packages were misdeclared on any to the railways, the penalty was imposed at the entire rake, your Lordship. Now, by the impugned order, a notification of the railway board has been read down, whereby instead of a penalty being imposed on the entire rake, penalty would be limited to the specific packages which are misdeclared. Now, the ramifications of that being felt across the country, your Lordship. Deeply obliged.
May I please, your Lordship, my lord? With the consent of the parties, I beg to mention item number 23 of today's daily list, my lord. The conducting council appearing for the state of Arunachal Pradesh, Mr. B.D. Goswami, my lord. He is on bereavement.
Item 26.
Item 23 and item 26 as well, my lord.
My lord, in item 26, I am there. I have had the application for vacating the interim order, my lord. Last time also, they took time to do the urgent matter. It was fixed today.
Okay.
And I talked to additional advocate general, another person in the morning, our phone. I know there was bereavement in his family. So let it be mine on Monday or Tuesday next.
Lordship, can it be after vacation, Lord?
No, it
We
will
have
be
filed
not.
our affidavit on today, Lord.
No. I will reply.
IL, Lord.
Tomorrow also will reply. But matter is extremely urgent. That's why Lordship wanted on the first day of the opening.
Lordship, there is not such urgency, Lordship.
We know. I am suffering. No?
Let us see on Monday and
Monday, yes. Because I am suffering. They are taking time. And
B.D. Goswami.
B.D. Goswami, my lord.
Then additional AG, Arunachal Pradesh. List the matter again on 8.
My lord, a similar pair for item 23 as well, my lord.
No, that is 23.
26, my lord. That was 20.
Mine is 26.
26. 23, when do you want?
Any day. He is for the appellant, my
For
lord.
Monday, Lordship.
Okay, both same orders.
On 8.
Deeply obliged.
Wait, please, your Lordship. My lord, I beg to mention item number 13, 1-3, my lord. We come after 1 week. We need some instruction, my lord. We need some instruction from the petitioner, my lord.
Okay, on request made by MS.
Yes, Bora.
Yes, Boral and counsel for the appellant. When do you want?
After 1 week.
List the matter on 22nd.
May I please, your lordship. Lordship, I'm praying for listing of a writ appeal, your lordship. Lordship, there the urgency is that, lordship, there is no stay order, lordship, and the department is going to issue the work order. It's related to tender matter. Lordship, if it is not inconvenient, Lordship, may I trouble you on for Friday, your Lordship? Much obliged, Lordship.
May I please, your Lordship? I beg to mention item number 8 of today's list, Lordship. Lordship, the conducting counsel for the petitioner, Lordship, he is sick, Lordship. Lordship, kindly adjourn this matter for this 2 weeks, Lordship.
You are appearing on behalf of?
Appellant, Lordship.
I'm for responding.
Lordship, I'm
No. Who's your senior?
Somo.
No. You are mentioning on behalf of?
Somo, Lordship.
Item number 8.
Item number 8,
Item number 8.
Oh, eight.
Lordship, Lordship.
Okay. On request made on behalf of Mr. H. Chamal and the council for the appellant, list after 2 weeks.
Lordship, I'm appearing for transport department in this matter.
MS,
MD Bora.
MD Bora, Learner Standing Council.
Trans-
for respondent
appears
number
for the
1.
transport department, and Mr.
B. Prasad.
P. Prasad, Learner Council appears for respondent number 1.
Obliged.
May I please, your Lordship? Lordship, I beg to mention IS Civil 23452023 for listing, Lordship.
Writ appeal,
No, sir, Lordship contempt, IS Civil in a contempt case also 4352022.
when do you want?
Maybe Monday, Lordship.
10th.
Let's.
Wait, please, Lordship. Lordship, I beg to mention item number 19, Lordship, with the consent of the respondent, Lordship.
19.
1919, yes,
Hmm.
Lordship. Lordship, this matter may come after 4 weeks, Lordship. We have to file our reply here, Lordship.
Okay, on request made by MS
M. Nirula, Lordship.
M. Nirula, Learner Council for the
Appellant, Lordship.
appellant, list after
4 weeks, Lordship. 4 weeks.
4 weeks.
May I please, your Lordship? Lordship, I beg apology, Lordship. In item number 26, there is an interim order, Lordship, that may be continued, Lordship.
Item 26, interim order passed related to continue till the next interim.
Deeply obliged, Lordship.
May I please, Lordship, because the default of paying of 2 installment in the bank is not going to attach my property. I just need my 1 month time to pay the amount, my lord. Lordship, I pray this matter may kindly taken out tomorrow, my lord, motion call. Newly filed.
I thought you were sick. Item 8, they mentioned that you're sick.
No, newly I have filed today a securitization matter where, my lord, we need certain protection from this honorable court to protect my property, my lord.
Okay.
Tomorrow, my lord, I
Day after tomorrow.
some, my lord, urgency, they are going to attach, my lord.
When are they going to?
My lord, the time is over on 1st, my lord, January 2024, my lord. Therefore, anytime, my lord, they may come for attachment.
Okay.
And my lord, item number, my lord, 10. As for instruction, my lord, this matter become infractions. Therefore, I would like to withdraw, my lord.
Mr. Shamal and the counsel for the petitioner submits that the matter has become infractious
Item number 10.
and prays for withdrawal of this present with petition. So, who appears on the other side? No,
My lord,
petitioner
central
is
council,
accordingly
there is no problem, my lord.
dismissed on withdrawal. Yes.
Deeply approved.
Look, I beg to mention item 9, Lordship.
Hmm.
Some instruction is required, Lordship, from the appellant side, Lord.
Hmm.
In this, kindly,
Your good name, please.
J.M. Sulaiman.
Okay, and request made by J.M. Sulaiman and the counsel for the petition, for the appellant. When do you want?
After 2 weeks
List after 2 weeks.
of that.
Item 1 for motion.
Hardly burdens. Yes.
Yes, may I please, the Lordship? Lordship, I am a registered society and I'm filing this PIL for 150 golden langurs of Bhairav Reserve Forest, basically Bongaigaon district. Lordship, golden langurs are found only in the Western Assam and in Bhutan, foothills of Bhutan. So nowhere it is found in the world. So the thing is that, Lordship, in a regional office of Guwahati, MOEF has already granted stage 1 forest clearance in favor of Nagal Bibra Bongaigaon Transmission Limited, Starlight Power. Lordship, this stage 1 clearance is basically for construction of 400 kV DC transmission line project from Bongaigaon to Nagal Bibra. Nagal Bibra is in Meghalaya and Bongaigaon is in Assam. Lordship, this entire project is going to be through the middle of the Bhairav Reserve Forest. This is the concern for which we have come before your Lordship. And Lordship, already 2330 number of species of trees have already been enumerated for cutting off and giving way to this project in Bhairav Reserve Forest. Lordship, I must speak about golden langours. This is very important from the point of view of conservation. Is that IUCN red data list has mentioned it is a decreasing trend, and it has been mentioned as an endangered species. Lordship, And it is in, but whereas in a Bhairav Reserve Forest, it is in increasing trend. In the year 2007, it was 49 in Bhairav Reserve Forest. Now it has increased to 150 numbers. So it is very important that this area should be kept inviolate and for the protection of the golden langurs. Lordship, and my PIL basically is not against development. We are not against, because the relief that we are praying for an underground construction of the transmission line. And also, if it is possible, through the fringes of the Bhairav Reserve Forest. So we are not stopping the project in totality, Lordship. Lordship, this project is going to be a disaster because it's going to bifurcate the entire whole reserve forest into two parts. Lordship, I have made an analysis of the map by which they have, because if it is built in the fringes areas, there to be only a few kilometers of distance will be there from the, if it is not done in the middle, if it is done in the periphery of the reserve forest. Lordship, and interestingly, Lordship, Department of Forest, Conservator of Forest, Lower Assam Social Forestry Circle, Bongaigaon, and Divisional Forest Officer, Ivoli Division, has already opposed this project. It is in Annexure GHIJ. Annexure GHIJ.
Page.
Annexure G is at page 83, H is 84, 85, and 86. Annexure G, it says that however the proposed transmission alignment falling at Bhairav Reserve Forest is one of the highest potential habitat of endangered species called Gondel langur, which is very much endemic to this part of state of Assam. The enumerated 2330 trees to be felled in a proposed transmission line alignment may adversely affect the habitat and survivability of the endangered species, as well as it will lead towards scarcity of food source for the primates. Further, the proposed high voltage transmission line will always be a big threat for the life of primate, which is a complete arable nature. So, Lordship, arable means something they live in the trees only. They don't come to the ground. And these trees serve as the food, because this species is something which they live only in leaves and on fruits, and fruits especially from the Gamari.
Yes.
Lordship may fix a short date. I'll seek instructions, and Lordship will explore the possibility of if underground transmission lines can.
How much time do you want?
Lordship, 3 weeks maybe.
3 weeks is not a short time.
Perhaps 2 weeks then, Lordship.
2 weeks.
Lordship, I want to make two submissions more. Number one is that already the tree cutting has already started. So a stay order may be granted that no further trees should be cut.
That will be difficult.
Already 200 trees have already been gone from the art.
They are saying you want to explore the ground. If you want to explore, what you can do is you can tell them to stop cutting. We won't pass it a stay order.
We'll explore the possibilities, Lordship, but at this stage, any interim relief might have final bearing, Lordship.
Lordship, we are not against the entire project, only in Bhairav Reserve Forest, Lordship.
And
only in Bhairav Reserve Forest.
the project has already proceeded, Lordship.
Why not you come back after a week?
If Lordship is so inclined, I'll come back after a week, Lordship.
Lordship, there is already a MOEF guideline which says that the forest area, the distribution company shall preferably use aerial bundle cables or underground cable.
Okay, heard Mr. A.K. Das.
Yes, much.
Learned counsel for the petitioner. Stop.
I Bhattakur.
Mr. I Bhattakur, Leonard.
Counsel for State Forest Department, Lordship.
Standing counsel.
State Forest, Lord.
Standing counsel.
On behalf of Standing Counsel.
Leonard counsel appearing on behalf of the Standing Counsel Forest Department. List the matter on after a week. We'll have it on 11th January.
Item 2.
May I please, Lordship? Lordship, on the last occasion, actually, the question arises of the maintainability of this street, because in this street we had filed for a breathing space till the next date of the DRT, which was on 23rd of February. So the thing is that what the maintainability of the rate is there. The thing is that the first, there are 3 points which I could like to go for is there. Firstly is that actually the natural justice actually. The thing is that whenever the bank gave me one letter, I want to take the possession of your house, I will have to pay to the bank the amount which I owe to them. That is a simple one. So when I deposited the account out in the bank, the particular bank says actually some petition was going in the was filed in the civil suit in Dibrugarh. So this account is been blocked. So my thing is that when I'm paying you, I have paid the whole amount, much more than that amount in my bank account. You just deduct it. This is the principle of natural justice has been violated, and that the same talking was also given to me at the honorable DRT also. Second stage is that actually now if there is a dispute between someone and me, actually the statute also says under section 26E, Mr. Bank, you deduct the amount. This is your money. Even if it is the money of some government organization or the taxes also, the first priority of the amount goes to the bank. And third is that actually, I am not filing an appeal over here. If somehow I lose the essay, actually, my appellant tribunal is at DRT Kolkata. Here I am just filing for a breathing space till the next date, so that my house, the property should not be seized, because the amount is with them only. Now, see, there's the three things that why this rate should be
You're
second-
challenging the order of the DRDA, isn't it?
Yeah, yes. As of now, yes, but only for the IA in the essay number 154.
No,
We
but
just
whatever
asked,
it is an appeal.
yes, my lordship.
So you have an alternative form.
But apart from that also, the statute said if some principles of natural justice has been affected, if the statute is there, we can approach over here.
Give me the surface area. Section 19.
Section 18.
Which section 18?
18, yeah. That I know, my lordship.
Then
But here the thing is that it is not the full-fledged order actually. It's just
whatever it is, what does it say? Any order.
Any order made.
Any order made
Yeah.
by the DRD. Any
Yeah, that's-
order.
that's true. But in the same DRT also, the thing is that 26E also says the amount, whichever the first priority is the bank.
That's a different issue.
That can take up in the appeal.
You can take it up in the appeal. You can take it up in the appeal. Why do you approach the appellate form?
Only the thing which I wanted for this read is that the natural justice of this.
Whatever it is, that also you can take up before the appellate tribunal.
If that is so, then my lordship, then I have nothing more to say for it.
Yes.
Nothing more to say.
So you can withdraw it and go appear before we pass the order of dismissal.
My lordship, I didn't hear it.
You can withdraw it and go before the tribunal.
That will do, man. I just want to withdraw it so that I can file it.
Mr. S. Majumdar and counsel for the petitioner, prays for withdrawal of the said petition with liberty to approach the appropriate forum. Stop. Mr.
A Dhanuka lordship. A Dhanuka
A. Dhanuka, Leonard counsel, appears for the
bank. Sorry.
Punjab National
Punjab.
Bank. Stop. This writ petition is dismissed on withdrawal with liberty as paid for.
Item 6 for admission.
May I please, your lordship? Pursuant to my lord orders passed by this honorable court, my lord, the authorities, they are searching out for an alternative plot of land. My lord, for being able to, my lord, settle in favor of the writ petitioner who happens to be the respondent number 1 here in my lord. The fact remains, my lord, that way back in the year 2005, on account of my
So
lord.
what happened? Have you found?
No, my lord, I have received an, my lord, instruction over WhatsApp this morning. My lord, authorities are still searching out. My lord, they are unable to, my lord, find out. In fact, my lord, the land has already been settled, alternative plot of land. But the petitioner is not happy with the one part of that land. He says that, my lord, that is not habitable. So therefore, kindly allot me some another plot of land. To that extent, my lord, the authorities are constantly taking up the exercise. There is a dearth of, my lord, government land.
So what do you want today?
My lord, lordship will kindly accommodate me for further some time. Otherwise, my lord, lordship will hear the matter on merit. Because this honorable court, my lord, expressed an opinion, my lord, on the last occasion, my lord, that instead of going into the merit of the case, that if things could be sorted out, my lord, between the petitioner and the revenue authorities, my lord, probably, my lord, that will be beneficial for the petitioner. In fact, he is also agreeable. Only thing is that, my lord, there is, my lord, very large scarcity of land, my lord, within the vicinity of Guwahati.
So how much time do you want?
Lordship will kindly accommodate me for another 4 weeks, my lord. If nothing for is forthcoming, my lord.
Already
Lordship-
2 years gone, my lord, for searching, my lord, alternative land, my lord. Last and final chance, my lord. Otherwise, my lord, petitioner is going to be old age it. And he is a handicapped person, my lord.
Okay, Mr. R. Barbujari, the counsel for the appellants submits that the respondents are still trying to identify a suitable plot of land for allotment to the respondent, and therefore prays for another 4 weeks' time to place the factual report
My lord.
on the court. Stop. The prayers allot list after 4 weeks.
I'm so obliged.
The date may be fixed, my lord.
List on 7th February.
Obliged.
Obliged.
Item 7.
May it please your lordship. Lordship, as per the order dated 8/6/2023, your lordship has allowed us to implement the Assam Rajiv Gandhi University of Cooperative Management as respondent number 5. We have already done the implement, and the amendment of post title is also done. So lordship, today I beg your lordship to kindly give us time to issue notice to the respondent number 5. That is the Assam Rajiv Gandhi.
No, notice is complete. Which respondent?
Respondent number 5, my lord. They were newly impleted, lordship.
The Assam Rajiv Gandhi University.
Yes, my.
When was it implemented?
8/6/2023.
8/6/2023. I don't have that order. Check up the date.
Is it a rock? Okay. Your lordship may kindly look up to this order. Don't have the
Is
extra.
it in the IA?
Lordship,
Okay. You can issue. Part MS.
Valentina Villabeno Tanyu.
That's a long name.
Yes, my lord.
Third name is V. Hanu,
Yes.
General Counsel for the application. Issue notice on the respondent number 5. The applicants to take steps for service of notice on respondent number 5 by registered post AD within 1 week.
Lordship, may can you give it like 2 weeks?
You can't take steps within 1 week.
We can, Lordship, like
You take steps within 1 week.
Lordship.
List the matter after 4 weeks.
Deeply of it.
Item 11.
My pleasure, Lordship. Sir, I am praying for adjournment only for today, Lordship. Otherwise, I have filed affidavit in reply, and respondent number 1 is yet to file their affidavit.
You want some adjournment today?
Today, Lordship.
Yes. Okay.
I am for respond number 11, Lordship.
On request made by MS.
Please, Aurea.
P. Saharial, the counsel for the petitioner. When do you want?
After 1 week,
After 1 week. List the matter after 1 week.
Aurea.
12.
May I please, my lord? Lord, the order passed by the learned single judge is under challenge. My lord, before the learned single judge, the respondents hearing, who were the petitioners, my lord, they claimed a higher grade pay. My lord, in terms of the office memorandum, my lord, dated 2009, my lord, which is at page 68. My lord, it is on the basis of the said OM that the petitioners, my lord, claim that they should be granted a higher grade pay from 4,200 to 4,600 and thereafter. Whereas, my lord, the contention of the respondents was that, my lord, that since they were already given the promotion, so, my lord, that promotion cannot be ignored. On the other hand, the petitioners, my lord, they claim that the promotions granted to them from the grade pay of 2,800 to 4,200, that ought to be ignored in terms of the OM. Now, my lord, I may take, my lord, to page 68, the very office memorandum. May I read the clauses, my lord? Page 68, my lord. May I read?
Yes.
My lord, it says, my lord, clause 5, promotions earned, upgradations granted under ACP.
Page 68.
Page 68, my lord.
Clause 5.
Clause 5 at the bottom, my lord.
There's 67, I think. It's 57.
There is no clause 5 at 68. Are you referring to annexure 1 which says modified assured carry of progression?
My lord, my lord,
That is at 67 in our.
my lord. My lord, may I read that, my lord? Clause 5. Promotions earned, upgradations granted under the ACP scheme in the past to those grades which now carry the same grade pay due to merger of pay scales oblique upgradations of posts recommended by the 6th Pay Commission shall be ignored for the purpose of granting upgradations under modified ACPS. Now, my lord will take the next page. The pre-revised hierarchy in particular organization was as under. So, my lord, thereafter the scales are given, my lord, 3 pay scales are given, that is 5,000 to 8,000, 5,500 to 9,000, and 6,500 to 10,500. So, my lord, it was these 3 pay scales which were merged. And the petitioners, my lord, they were not in that pay scale. They were, my lord, if I may, my lord, I have given one table, my lord, which shows the comparative study of the 4th pay, 5th pay, and 6th pay CPCs, my lord. It starts with table showing 4th CPC pay scales, my lord. Has got it.
Yes.
My lord, My lord, here at clause number 9, serial number 9, my lord will see the pay scale that is at 5th CPC, which the petitioners were in. That is, my lord, 4,500 to 7,000. And my lord, the corresponding 6th pay scale is 5,200 to 20,200 with grade pay of 2,800. My lord has got it. And my lord, from 2,800, they were promoted to the next scale, my lord, that is at the bottom, 5,000 to 8,000. Therefore, meaning thereby, my lord, they were promoted from grade pay of 2,800 to 4,800, 4,200. So, my lord, this was the promotion which was granted to them in, and my lord, what was merged is, my lord, will see at serial number 10, 11, and 12, my lord, there are 3 pay scales with common grade pay. That is 4,200. So, my lord, what was contemplated by the office memorandum was that, my lord, those pay scales which carry the same grade pay, those were merged. The petitioners, my lord, were in the grade pay, their initial recruitment was in the grade pay of 2,800. Thereafter, my lord, they were promoted to the grade pay of 42, and consequently, regular SCP, MSCP benefits were given to them, my lord, which we have filed in the additional affidavit. My lord, in the annexure, we have given a detailed chart of all the benefits which were given to them from time to time. So, my lord, if I may read further from the, my lord, the office memorandum, which says, my lord, a government servant who was recruited in the hierarchy in the pre-revised pay scale of 5,000 to 8,000, it is only applicable to them, my lord, not to those, my lord, who were in the pay scale of 4,500 to 7,000. So therefore, my lord, the promotion granted to them from the pay scale of 2,800 to 4,200 will be treated as a promotion, and my lord, should be treated as a promotion. And this OM, my lord, is not applicable in case of the, my lord, petitioners. My lord, in support of my contention, my lord, I am also relying on a division bench judgment wherein, my lord, this clause 5 was interpreted. And my lord, if I may take, my lord, to the relevant paragraph of the judgment, that is 2019 4 GLT 760. Paragraph 25. Similar issue, my lord, came before the division bench. The clause 5 was interpreted, my lord.
Yes.
I will read the paragraph 25, my lord. The post of DEO carried pay scale of 4,500 to 7,000, exactly, my lord, in this, in our case also, in the 5th CPC. In 6th CPC, the said scale is placed on pay band 1 in the pay scale of 5,200 to 20,200 with grade pay of 2,800. It is significant to note that in the 6th CPC, the said pay scale has not been merged with the next higher scale, which is 9,300 to 34,800. The grade pay is also not 2,800, but varies from 4,200 to 4,600, 4,800 and 5,400. The substratum of the argument of Mr. Datta is that all promotions earned earlier prior to his induction in the IT cadre, in which junior engineer grade 2 has been shown to be the entry cadre, is to be ignored. The argument is fallacious. In first place, actually it is not the case presented by the petitioner that from the post of DPS he was placed in the post of junior engineer IT grade 2. It is his own case of the petitioner at paragraph 4.1.2 of the OA that he had been deployed in the new cadre as senior engineer IT grade 2. Under MSCP scheme, there shall be 3 financial upgradations counted from the direct entry grade on completion of 10, 20, and 30 years respectively, and such upgradations will be admissible whenever a person has spent 10 years continuously in the same grade. Direct entry, as is referred to in the MSCP scheme, cannot be correlated to any subsequent revision of clarification of posts, also indicating that a particular post will be a post in the entry cadre. The petitioner was observed in the IT cadre, in which junior engineer IT grade 2 is a post only on 1/4/2005, and if the petitioner's contention is to be accepted, then for him the period of 10 years starts from that date. Now, my lord, this is important, my lord. Where is the interpretation of clause 5 has come, my lord. To overcome that, it is also sought to be contended that for the purpose of MACP, the entire period has to be otherwise reckoned. In other words, the contention advance is that the respondent should ignore all promotions earned earlier, but should take the total length of service for the purpose of MACP. This is not the object and purport of MACP. Clause 5, which deals with the promotions earned earlier, provides that if due to merger of pay scales, upgradations of the posts recommended by the 6 CPC, promotions earned, upgradations granted under the ACP scheme in the past to those grades which now carry the same grade pay will have to be ignored. If it is not to the same grade pay, it cannot be ignored. Therefore, the promotion from the post of DEO in the pay scale of 4,500, 7,000 with the grade pay of 2,800 to the post of senior DEO in the pay scale of 5,000 to 800 with the grade pay of 4,200 has to be considered as one promotion. So here, my lord, our contention is, my lord, exactly the same, my lord, that the promotion from the grade pay of 2,800 to 4,200, my lord, should be treated as one promotion. And we have given subsequent benefits, whatever is accrued, my lord, as per the ACP and MACP scheme, my lord, which we have, my lord, stated in our additional affidavit, if my lord may peruse. Page 110, my lord, running page 110 of the additional affidavit which we have filed, my lord. My lord, the details of promotion of in respect of all the, my lord, 18 petitioners, my lord, we have given, my lord. My lord, we'll see, my lord, if I take the example of the first petitioner, my lord, he was appointed, my lord, it is mentioned, date of the appointment with initial grade pay, my lord has got it. After the educational qualification, my lord, there is a column date of appointment.
Yes.
With initial grade and pay. Now, this is the initial appointment, my lord, where mentioned the pay scale and the GP grade pay is 2,800. Thereafter, my lord, he was promoted. My lord, next column is promoted to, my lord, draftsman 1, my lord, with effect from 1/4/2000. That is at grade pay 4,200. And thereafter, my lord, if will, my lord will see the further columns, MACP 2 benefits and MACP 3 benefits were given, my lord, at grade pay of 4,600 and 800 respectively. Now they are at level 8. My lord, whatever the financial benefits were due to them, they were already been granted. Now their contention was that, my lord, that the, my lord, their grade pay should start from 4,200. And the grade pay of 2,000, the promotion from 2,800 to 4,200, that should be ignored in terms of the OM. My lord, but the OM is, my lord, not applicable to them because they are not falling within that pay scale. This is our contention, my lord.
Yes.
Lordship, the affidavit my friend referred to, I didn't receive properly. How come? I don't know.
You have not received a copy of the additional
I
affidavit?
don't have it now. I didn't receive.
Have you printed a copy?
Yes, my lord. We have punished without punishing, my lord. It cannot be filed. Did you? Nine. Yeah, that too. Notice. Yeah, this is. I can file.
When did you file this affidavit?
My lord, the sleep. Sleep was there. I didn't sleep.
7th of December.
My lord.
One MS D Mahanda has accepted notice.
Maybe lot. I'll verify that lot. Somebody has received. But today, 7 not if I don't have it. But may kindly consider.
So, you have any extra copies?
My lord, I can furnish one.
You furnish a copy.
Extra copy actually. Otherwise, Her Lordship may find at page 30, the judgment, Lordship of passed by the Planet single judge. These things were considered, Lordship.
Page?
It starts at page 26, Lordship. 29, Lordship will find paragraph 3. I am reading that. The brief facts of the instant case is that the petitioners herein, except the petitioner number 2, 10, and 18, were appointed on various dates in the year 1988. The petitioner number 2 and 10 were appointed on 28/8/1981, and the petitioner number 18 was appointed on 21/10/1982. All the petitioners were initially appointed as draftsman grade 2. It can also be seen from the record that all these petitioners were also promoted to the post of draftsman grade 1 on various dates. The pay scale of the petitioner in pursuance of the recommendation of the Fifth Central Pay Commission was revised to 5,000 150-8,000 with effect from 1/1/1996. In the case of the petitioners that the Sixth Central Pay Commission recommended for maintaining the relativities of senior draftsmen with
Okay.
Lordship.
Let me but H. Learn the council, learn the CGC.
At that point of time, Lordship, they were receiving this pay scale, Lordship, 5,000 to 8,000.
We'll admit it. We'll hear you later. H. Gupta, learn the CGC for the applicants. Admits. Mr. M. Sharma, isn't it?
MP Sharma.
MP Sharma. Learn council. You are appearing for?
I appear for all the respondents.
Appears on behalf of all the respondents. Stop. List the matter for hearing. When?
Immediately after being.
After Minu you want? On 30 January.
No. Right. Public.
Is there a caveat?
Caveat was there, only it was already discharged.
Already discharged?
Already discharged.
No, it's not discharged.
Okay.
Caveat is discharged.
And that on
There's no order as such.
Malad.
Here the caveat.
Malad.
Part MP Sharma, then the council for the caveat. Caveat stands discharged.
Item 14.
Before my learned friend starts with his matter, my lord, copy of the retable has been served on me today after the delay was condoned. So I might be given an opportunity to go over it and place my case before it is taken up for admission hearing.
Well, the delay that has occasioned in filing this writ appeal has already been condoned. Thereafter, this writ appeal has been numbered. Today, it has come up for admission. Not only difficulty was that my learned colleague was devoid of any copy. Today, I have furnished the copy, my lord.
So he wants some time?
Yes, my lord. And my lord, one another aspect of the matter, my lord, there is a stay petition which we have filed. That may be numbered, my lord. It is there in the case record, my lord. 1I, my lord. That has not yet been registered, my lord. It is stay petition.
Why is it not numbered? Okay, heard Mr. R. Barbajani, then let's counsel for the appellant stop. The registry is directed to number the stay, the IA, praying for stay of the, uh, praying for stay. Stop. List the matter again after 1 week.
Well, instead of next week, it would have, maybe after, immediately after Bihu. Let it come after, my lord, 2 weeks, my lord.
After 2 weeks. 24th.
Lordship, may kindly be pleased to observe, my lord, that I have already served in the copy,
Done, sir.
my lord. I'm so,
15.
Mr. Lordship, possible for the time being, my lord,
Why time being?
as Mrs. Lord Chaudhary is in use of the case.
Hmm? Just some time.
Item 16.
Please, your lordship.
Yes.
My lord, in this matter, we have challenged the judgment of the honorable single judge, my lord.
Hmm.
It is at page 81, my lord.
Yes.
Page 81, my lord. I'm reading para 2, my lord. By filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities for making payment of a sum of rupees 9,96,384 only as arrear enhanced rent for the period 1/5/2020 to 31/12/2022. In brief, the case of the petitioner is that while agreement dated 1/5/2017, he had let out his ground floor plus one-story RCC building to the Pollution Control Board Assam initially for a period of 3 years at the provisional rent of 38,000 per month, which was to be assessed and fixed by the PWD Building Division 1. After expiry of the agreed term, the Pollution Control Board did not enter into a fresh tenancy agreement with the petitioner, and therefore the petitioner had requested the Pollution Control Board Assam for enhancement of the rent as per the assessment made by the PWD. The representations to the Pollution Control Board for enhancing their rent did not yield any result. However, the Pollution Control Board Assam had vacated the tenanted premises on 31/12/2022 without paying the arrear enhanced rent from 1/5/2020 to 31/12/2022. Hence this writ petition. So, my lord, the relevant portion which we have challenged is at page, my lord, 86, my lord. 85 is also important, para 9, my lord. Under the such circumstances, this court is inclined to invoke the writ jurisdiction of this court under Article 226 of the Constitution of India to direct the payment of enhanced rent to the petitioner in terms of the letter dated 1/8/2022 issued by the Member Secretary Pollution Control Board Assam to the petitioner, wherein the said authority has agreed to consider the payment of the rent at the rate of 23,000 per month for the ground floor and 25,000 per month for the first floor, effective from 1/5/2022 till 31/12/22, when the Pollution Control Board had vacated the tenanted premises. Then the last para, my lord, at page 86, which we have challenged, my lord. The last para, my lord, it is under such circumstances that this court is inclined to invoke extraordinary jurisdiction in the matter to direct the respondent number 2 to 6 jointly and severally to make payment of the sum 23,000 per month for ground floor and 25,000 per month for first floor. But this is the amount, my lord, which was offered by the Pollution Control Board, which the petitioner did not accept, my lord. The petitioner, my lord, requested them to make the payment as per the assessment made by the authority, my lord, appropriate authority, which is at page 41, 42, and 43, my lord. This is page 41.
Wait, please, my lord.
My lords, my lord, the main respondent here is the Pollution Control Board. My lord, the Learned Standing Council is not present, so perhaps it would be
He was here, my lord.
appropriate that he be present when the matter is heard. Mr.
Who's
S.
the-
Borua, Mr. S. Borua, my lord.
He was here, my lord, in the morning.
Yeah, continue. Continue.
Para 41, my lord. Assessment of house rent of office premises, regional office, pollution control board, Golf Press Road, Bamuni Moidan. With reference to your letter dated so and so, as per the regional office pollution control board, so and so letter, so and so. In this connection, the detailed valuation report for the ground floor and first floor have been submitted by AEE PWD Dispute Territorial Building Subdivision, Guwahati, for the said building. The land valuation for the said building has been received from Additional Deputy Commissioner, Kamrup Metro, by letter dated so and so. Accordingly, the rent of the building is calculated floor-wise as per Assam Urban Area Rent Control Act 1972. The rent calculated sheet is enclosed herewith. My lord, the next page, my lord, page 42, my lord. This is, my lord, rupees 25,000, my lord. 25,000. And the next is 43 place 38,000, my lord.
Where
This
coming with
calculation was made
25,000?
by the
Where's
appropriate authority.
25,000? Where's 25,000?
25,000 at page, my lord, 30,000, my lord.
That's what you're asking.
Yes, my lord, 30,000. And page 43 is 38,000.
Hmm.
And the Honorable Single Judge has passed an order, directed the respondents to pay the my lord, rent as per the offer made by the respondent authorities, not as per the calculation made by the appropriate authorities, my lord.
Where's that?
That is the direction is at page 86, my lord.
Hmm.
This part we have challenged, my lord. There's 23,000 per month for ground floor. We should be 30,000 and 25,000 per month for first floor, that it should be 30,000, 38,000 as per calculation, my lord, at page 42 and 43. And this was the prayer in the writ petition also, my lord.
Yes. Who applies for the pollution control?
I'm appealing for the board.
Yes.
In fact, the board has rightly assessed, and in fact, for that matter, the PWD has been asked to make the assessment and give it. But for that matter, the petitioner did not approach in the right time. Finally, they have been given with extra opportunity to go and give the assessment. And accordingly, that assessment, based on the PWD, because this is a government establishment, we have to be abiding the PWD guidelines.
So accordingly, the PWD has made its assessment, isn't it?
Yes, that has been made later on the instance that we have requested the petitioner. But they on their own volition haven't approached the PWD, and for which.
Whatever it is, they have approached the
Yes,
PWD.
yes.
PWD has made its assessment.
Yes.
So you'll have to go according to the PWD
No,
assessment, isn't it?
that is with regard to the subsequent dates. With regard to the previous tenancy amount, that has to be guided by the agreement that they have entered into with the board.
Hmm. So we are on the period 1/5/2022. to 31/12/2022, isn't it?
Yes, that is the period.
Wow. So for this period, were there any agreement?
Yes,
There was no agreement.
No agreement was.
There was no agreement.
there was no agreement because
There was no
already
agreement.
that agreement has been exhausted prior to this date.
Yes.
And finally, for re-entering, again, the assessment has to be done and we have to go. And the board has already intimated them as regard just leaving the property because we wanted to shift it off to some other place. And that has been intimated. Now they're claiming over a amount which has already been settled. And in fact, this honorable court in single judge also had the opinion because this is a disputed question of fact that has to be decided by the civil court. So even then, as a special case, some indulgence has been given into this kind of case because ultimately that proving the contentions of parties has to be before the civil authority. This is a disputed question because we haven't admitted any of the claim that has been made by the petitioner. But still then the single judge has gone into.
After the assessment, my lord, the petitioner also informed the respondent authority, page 44, my lord. With reference to above, I have the honor to submit herewith an original letter forwarded to me for reassessment for rent by PWD Dispur so and so. Then for your kind necessary action. Then again, the respondent sought clarification. Your lordship may kindly see the next letter, page 45. So on receiving this letter, then the petitioner again wrote another letter by clarifying the whole thing, my lord, at page 47. In reply to their, my lord, letter, my lord. That is it, page 47.
Para 11 of the judgment.
My lord,
Para 11 of the judgment.
para 11. It is made clear that payment of admitted rent would be not be a bar for the, yes, man. It is said that there will be no bar. My humble prayer is that the let the my lord payment may be made as per the calculation made by the appropriate authority, not by us or by them, my lord. By appropriate authority is the PWD, my lord. On the last occasion, the learned counsel for the PWD also admitted this, my lord, that we are the authority who calculate.
No, I'm appearing for the PWD. Like here, no relief has been, no relief is against us. Ultimately, PWD is the assessing authority. Whenever they come,
Whatever you assess,
we have assessed.
that is the final.
Whatever assessment they will be made, we will be abide.
Yes, it has been already done, my lord. It has been already. So, my lord, the honorable court has already directed, Lordship has indicated, my lord, at page 86. The page 86, my lord. Liberty has been given at paragraph 11, Lordship has indicated, and page 86, my lord, from bottom, Lordship, around 10 lines. It is under this circumstances, this court is inclined to invoke the extraordinary jurisdiction in the matter to direct the respondent number 226 jointly and severally to make payment of a sum of rupees 23,000 per month on the ground floor and rupees 25,000 per month on the first floor from 1/5/22 to 31/12/22 in terms of the letter number so and so dated 1/22 issued by the member secretary pollution control.
This is the one
This is the
offered by the pollution control board.
The assessment made by the PWD has been ignored.
assessment has been made by the PWD and that is
Page
there,
41, 42.
So that is why learned single judge did not consider the assessment made by the PWD, isn't it?
But even if but Lordship, that's been noted here, my lord. Page 82, para 5.
And this is offered by pollution control board, page 49, annexure K, my lord.
Para 7 also, my lord, the later executive engineer PWD Dispur and Guwahati East Territorial Division, Guwahati by letter number dated 21/5/22 has forwarded statement of calculation. If my lord, if this amount is disputed by any of the party, even if it is assessed by the PWD, then therefore my lordship has directed that the admitted amount be paid and then the parties have been given liberty to approach the civil court for determination of just and fair rent because the parties are disputing the rent.
Where is the dispute, Mr. Barua? What dispute? What dispute is that?
Dispute, in fact,
PWD made the assessment, correct? PWD is the assessing authority, correct?
that
PWD
assessed amount we are ready to give, but they are claiming an amount which has prior to that assessment, because ultimately assessment is done on yearly basis. On that, they're claiming of amount where that assessment hasn't been made by the PWD.
No, PWD has made the assessment.
That is, Lordship will go into the years when the assessment, the petitioner would be in the right position to explain what all years the assessment they are claiming for. So they are claiming for a years of assessments for which the PWD hasn't entered into the picture.
Where is that? Show us.
Lordship will go to Lordship will go to page 51. Page running page 67. Page 67.
67 is something else. 67 is the old.
The pages are not telling with my set of petition. That is the letter. This is part of the affidavit that the pollution board has filed. This is letter addressed to the executive engineer PWD by the regional office of pollution board on 10th of November 2022. In fact,
You're referring to the letter dated 10th November?
Yes. May I know the?
68.
In fact, all the pages are not telling with my petition. Yes, but here it is shown to be 68. Okay. Yes, yes. Yes. So assessment of house rent of the office premises of regional office Guwahati so and so Bamoni Madam. With reference to the above, it is to inform you that this office is functioning from the rented house. Detail of the house of furnished as schedule with the Bamoni Madam since long back. The last tenancy agreement expired. The tenancy agreement has expired. Lordship would kindly take note of that fact. 1st May 2020, but fresh tenancy agreement could not be drawn at that time due to COVID pandemic. However, we have to clear the arrears since 1st of May 2020 on account of house rent revision, which was due on 1/5/2020. Therefore, you are requested to provide the office a house rent assessment report for ground floor, first floor separately as per rates prevailing. That is on that particular point of time. That is 1/5/2020. This letter has been addressed on 2022, and the assessment has to be done on the date of 1/5/2020 to enable the office to clear the area dues on account of the house rent since 1/5/2020.
Then
So
after this, what happened?
after this order, would kindly just turn on to the next annexes that is part of the report. Then we have addressed them that we are vacating the premises. We don't want to continue with the tenancy. But then the next annexer is annexer 3.
Mr. Borma, where is the assessment? You are saying there is some dispute. Please show that.
PWD assessment.
Yes.
Page 41.
Where on that? 41 is the assessment.
Yes.
So what dispute is here?
No, we are ready to give as per this, but they're claiming over an amount when the tenancy did not survive.
That you cannot take because you did not renew it.
Yes, we didn't renew it. And there we have to be guided by the existing rates that are being prevailing. And for which the court has also gone into that aspect that these kind of disputed things can.
You are trying to take the advantage that you did not renew the tenancy.
No, we didn't take the advantage. But we
trying to take the advantage. You are trying to take the advantage.
No. We have in fact requested the petitioner to come up with the PWD rate chart.
So he has
that assessment.
PWD has given the assessment.
May I be given one more day so that I can just explain it in details, because today maybe I may not be able to explain the parameters under what circumstances we have to go on for a renewal. So I will just come up if at all this matter may be taken up tomorrow or day after anything.
Okay. First, SP Chowdhury, learned counsel for the appellant. On request made by Mr. S. Barwa, learned standing counsel.
Pollution Control Board.
Pollution Control Board Assam. List down when?
Day after tomorrow.
Okay, 5th January.
Item 17 for orders.
May it please your lordship. Also, this is with regard to construction of that road in Malibagan area, just by the side of the boundary wall of the Milord High Court guest house. They were supposed to get the instructions when the constructions will be completed, because this is a long pending
issue.
But I have received some instructions in this matter, but some technical issues are there, that is why they could not start the construction work. Now they have informed me that the retaining wall structure as per the drawing, the suggestion is that the base of that particular retaining wall has to be more than 5 meters aside. But if they construct the position of the retaining wall as it is in the drawing, if they construct it, the wall will go to it will touch the basement of that existing building. So some technical issues are there. But I have received the latest instruction with the diagram of my authorities. I'll file an affidavit in the matter, and ultimately this matter to deliberate on the technical issues. It would be better to place it before the committee, because the committee is taking on the matter, the committee of the honorable court order, the honorable court.
This
The
item-
issue
17.
17.
17.
Look, the decision for construction of the road has already been taken.
It is taken, but
Only this
ultimately
technical things are there. IIT's help was taken, my lord. IIT has already provided the drawing, my lord.
no, that drawing is not workable. That is what the diagram has been given to me, that the retaining wall as has been proposed in the diagram, that cannot be constructed at that particular place, my lord. That has to be placed before the committee, my lord. That is why, my lord, I pray either, my lord, lordship may give me 2 days time, my lord, I will file an affidavit in the matter, my lord, bringing that diagram, where they are finding the difficulty, or lordship may kindly place the matter before the committee of the honorable court, which is looking after this case.
Okay, let us see your affidavit first.
Yes. I'll
But
file
what
the
your
affidavit.
lordship's
Can you come up with some other alternative also?
Because the retaining wall proposes 10 meter and the basement of
No,
the.
you're just saying that there's some technical
Issues,
problems.
yes.
All right.
Yes.
Can't you come with some other alternative?
But that Milord, already they have written 2-3 communications. They have already written to the expert of the IIT Guwahati. Response is not coming. I'll place it also in.
Milord, may I suggest one thing, Milord?
I'll also-
Previously, we have done this, Milord.
Yes.
The PWD people, IIT people, Milord, they appeared, they came before this, the building committee, they appeared, they given a presentation, then they explained them everything to the building committee. Then building committee, Milord, took a decision previously also. If that exercise can be done now, because going by the Milord, submission of my learned friend, now it has come to a standstill. So let the officers from IIT as well as from PWD, Milord, appear before the building committee and explain the building committee about the technical problems.
Correct.
And what can be, Milord,
That
solution can
that
be.
will be that will be better. That will be better. Lordship
Because-
may kindly direct to place the matter before the committee. We will, my officers and the IIT expert, they will appear before the committee and they will explain what difficulty they are finding, because the solution can be find out there. We are lawyers, my lord. We are not very expert in those.
Because at one point of time, this honorable court has taken a decision that we will leave a portion of the land of the Guwahati High Court so that the road can be constructed.
Correct.
Because that's wall we are unable to close that open portion of the wall, which is again a security issue and
Correct.
all those things for the entire campus, Milord.
Okay.
So let the entire matter be placed before the building committee once again.
You can hurt Mr. H.K. Das.
I'm a private respondent. What happened there? One security gate is been constructed in the road. It is
Let us see what the building committee says.
Yeah, it should be done on an hourly basis.
Hurt
because
H.K. Das,
they're
London
dealing
Council
the
for the
matter
Petitioner.
with the PW.
Stop.
No, PWD is trying, but it has
Mr.
to be
T.
it has to
Nath,
be feasible.
Leonard's senior government advocate, submits that on receipt of the drawing from the IIT, the respondents are facing some technical problems in implementing the same. And therefore, it would be appropriate to place before the building committee of this court. Stop. Accordingly, we direct the representatives of the IIT and
The PWD official.
and also the PWD officials to be present before the building committee of the Guwahati High Court on when do you want?
বিহুর আগে আগে কমিটি ফিক্স করো হ্যাঁ কমিটি ফিক্স না হলে কোর্টে next week any date I'll inform the officer.
Next week on 10th.
On 10th.
Fine.
10th. Gotcha.
On 10th of January 2024.
Time to be fixed by the registry, my lord. That's
Stop. The registry is directed to place the matter before the building committee and fix the time for the appearance of the representatives of the IIT and the PWD personnel before the said committee. Stop. This matter again on 22nd.
man. In the meantime, my friend can file the affidavit, whatever he wants
In
to
the
file.
meantime, former Mr. Dinat is permitted to file an affidavit explaining the technical problems
Yes.
faced by the respondents.
Highly obliged.
Item 18.
May I please, your lordship? Lordship will take fresh steps. Kindly allow us some time.
What fresh steps? You have not taken steps.
No, my lord. We have missed it out.
How?
I apologize, my lord.
Mr.
Our best, Purva.
Our best Learned Counsel for the applicant submits that due to inadvertence, he could not take steps for service of notice on the respondents 8 to 24 and 26. So, accordingly, one last opportunity is allowed to the appellants to take steps for service of notice on respondent number 8 to 24 and 26 by registered post, AD within 1 week, 1 week from the date, after 4 weeks.
Item 20.
My lord, as per last order, my lord, respondent 8, my lord, the affidavit is required because
May please, your
respondent is the 8 is the impleted, newly impleted.
Today we are filing the affidavit. In this matter, my senior Dinat is appearing, my lord. Today we are filing the affidavit for respondent number 8, my lord.
Okay, AMS MD Bora, Leonard,
State Council.
Governor Advocate, submits that they are filing affidavit on behalf of the respondent number 8 within the course of the day.
My lord.
Accordingly, list this matter after
Sir, my lord, 2 weeks, man. After due vacation.
2 weeks.
I'm appearing for Dima Haftar, your lord. I'm appearing for Dima Haftar.
Okay, MS. R. Dekar, Leonard Standing Council, Dima appears on behalf of the Dima Haftar Council.
Bless you.
21.
May I please, your lordship?
Yes.
Lordship, the service is completed. And the affidavit for dusty service was also filed on 19/12, lordship.
When did you file? Where is that affidavit?
Lordship, the affidavit was filed on 19/12, lordship.
Is the affidavit okay?
That's what I
This respondent 4, 5, and 6. How can you say that the notice has gone to them?
Lordship, same person has accepted on behalf of all the.
How can it be? This is supposed to be by dusty service.
Lordship, the sea service was done, Lordship.
So they are supposed to accept it personally, isn't it? Babul Nath, Sharmishta Nath, Pranab Nath, who has accepted notice on the behalf? This 2% cannot.
Let me see who mayor is. Paragraph 4, mayor also in that affidavit.
And who is this mayor? Mayor.
Lordship, he has accepted on behalf of VN Infra Projects.
Council, this court is asking you who is mayor. Have you disclosed who is he?
Lordship, it's not in my knowledge, Lord.
Then we can't accept this.
Lordship, I may ask the department for some instructions.
No. Whatever it is, this Babul Nath, Sharmishta Nath, and Pranab Nath,
Lordship.
how can this the seal is of a company, isn't it?
Lordship.
Then how can you say that notice is complete? With regard to 1, 2, and 3, this we may accept, but not 4, 5, and 6.
Lordship, for 5 and 6, we may take fresh steps. Lord.
How about this 1 to 1, 2, and 3? Is it okay? Royal BNI LLB.
This is an LLC. Number 1 is a JV. I can take fresh steps or not.
No. I think you'll have to take fresh steps or not. This time you'll have to be very careful.
Lordship.
GN infra project and
Oh.
three. 1 and 2 are different.
1 and 2 are different. The seal is of only one BN Infra Projects LLB. That is R3.
Lordship.
So you'll have to take first steps.
Lordship.
But Mr.
Why were we, Lordship?
Why Barbayan Learned Counsel for the appellant? Stop. Well, peruse the affidavit filed by the appellant showing service of notice on the respondents by dusty service. Stop. However, on perusal of the same, we are unable to accept that notices have been served on the respondents. Stop. Accordingly, the appellants are directed to take first steps for service of notice on the respondents by dusty service to the registry of this court within a period of 1 week from today. Stop.
I'm okay.
List again after 3 weeks.
Item 22.
May it please, my lord. My lord, in this matter, I appear on behalf of Mr. P. N. Goswami, the learned additional AG. My lord, there is some inconvenience on his part, my lord. He has gone for a medical checkup. Therefore, is requested that the lordships may be pleased to hear the matter after 3 weeks, my lord. We would like to address your lordships on this matter.
Okay, on request made on behalf of Mr. B. N. Goswami, Learned Additional Advocate General Assam. List the matter after 3 weeks.
I'm obliged.
24.
May please, my lord. My lord, the last one is 1910, my lord. Amended course title directed to be filed, my lord. But due to the lapse of my clerk, my lord, I did one more week, my lord, for compliance.
Okay, Mr. J.B. Sharma.
J.B. Sharma, my lord.
The counsel for the appellant. Press for another 1 week time
1910.
to file the amended course title. Stop. List after 1 week.
That's all.
25.
May I please, your lordship. Lordship, in this matter, I was granted liberty to serve dusty service to respond number 6, my lord. Yesterday only I have received the communication, so I have to file an affidavit to that effect, matter. I have served the notice.
Okay.
Copy have to be served to the government also.
Your good name, please?
H. Rahman.
Mr. H. Rahman and the counsel for the petitioner. Press for a week's time
Which time is
to file an affidavit showing service of notice on
Correct.
respond number 6 by dusty service.
obliged?
Press allowed. List after 1 week.
27.
May I please your lordship, my lord, we have taken fresh steps, my lord, but the service report on respond number 2 is awaited, my lord. Last office not showed yet, my lord.
When
I
did
am-
you take steps?
On
lord,
2/12.
Today I have filed my lord for respond number 2, my.
Oh, he.
You file your vakalat number? How about this one, number 1?
Respond
I
number.
have heard the respondent number 1.
Okay. But Mr. Deborah, Leonard Council for the Leonard Standing Council,
Health.
Health and Family Welfare Department. Stop, Mr.
Yes, Burman.
S. Burman, Leonard Council enters appearance on behalf of respond number 1. And Mr. M. Kalita, Leonard Council enters appearance on behalf of respond number 2. Stop. Only 2 respondents are there?
Yes, my lord, only 2.
The notice on respondents are complete. Accordingly, list this matter for admission after 2 weeks.
Yes, my lord. Obliged, my lord.
28.
Wait, with the lordship. And here there is a delay application, my lord. Notice on the respond number 8 has not yet been served, my lord.
Anybody appearing for respondent number 8?
No, I'm appearing for 2 to 5.
2 to 5, my learned pen is appearing for
For 6 and 7.
6 and 7, my lord.
Prohibited.
Notice has not been complete.
Yes, my lord. I have seen the office note, my lord.
So what do you want to do?
In fact, I have last opinion, also I have taken 3 steps, my lord. On, I think
Respond number 8.
8. My lord, I'll do one thing, my lord. I'll take the proper address on the respond number 8. Maybe he may be transferred to the other place, my lord.
Okay.
So, my lord may give me 1 week time. I'll try to get the proper address and I'll take the step, my lord.
Mr. N.G. Khatania, Leonard Counsel for the applicant. Press for 1 week time to ascertain the proper and correct address of the respond number 8. Stop. Praise the Lord. This stop to 1 minute.
Obliged.
29,
My lord, in this case, I was supposed to file objection, lordship, regarding one condonation petition. My petition is ready, lordship. I am going to file it today.
12 days, only 12 days, man.
12 days, you want to have some objection?
Lordship, I'm preparing the objection, lordship.
In
I'm
the,
going to file it today, lordship, after 1 week.
appeal may file objection. 12 days may be condoned.
Appeal, where's the scope to file an objection?
Yeah. Of course, I don't know.
Regarding condonation, lordship, I have some.
You are appealing for respondents?
Private respondent.
Private respondent.
1 to 5.
Lordship.
You have serious objections?
Lordship.
It's a right, my lord, right of a land, my lord. That's
Are you
what
having serious objections in continuation of 12 days?
Lordship, yes, lordship.
What objections do you have?
Lordship, there says, lordship, there is 12 days delay, but for me, lordship, it is 13 days. And regarding filing of the lordship case, lordship, they says, lordship, they file it on 3rd of August, but they filed it on 8th of August.
8 of August. 8 of Your lordship will find there in the appeal. There is
Let me,
a
lordship, file my
left hand
objection,
column. There is a
lordship.
registry has given the calculation. man.
Yes. Then the delay part,
Lordship.
12 days delay,
1 day delay, they did not explain, lordship.
what difference will it make?
And lordship, regarding the medical, they says, lordship, the engaged lawyer, lordship, having high blood pressure, but lordship, in this petition, they did not annex any medical document.
I think we should condone it. You object in the.
Appeal of your
Why don't you contest the writ appeal?
Yes, my lord.
But Mr. B. Sinha, and the counsel for the applicant. By this application, the applicants have praying for condonation of 12 days delay in filing the connected writ appeal. Stop. Hurt MS N. Bodole, Leonard, Hurt MS R. Gogoi, na? Leonard counsel for the respondents 1 to 5. And MS
S4 for respondent number 8.
S. Conor for the respond number
8.
7.
7.
This is
This is 7. 7.
Respond number 7. And MS
I'm for
N. Bodole for Learner Standing Council Revenue Department for the respond number 6.
6.
Stop. Para. After hearing the learned counsel for the parties and on consideration of the cost shown in the present application, we are satisfied. Stop. Accordingly, the delay of 12 days in filing the connected writ appeal is condoned. Registry is directed to number the writ appeal and list the matter in its usual course.
Obliged.
If it is in the writ appeal, I think. Let it come up when the writ appeal comes.
item 30,
May it please your lordship. Lordship, we have received our instruction and we need some time to file our objection.
Okay, heard Mr. B. Chakravarti.
CGC.
Let us CGC for the applicants. Stop. Mr.
And Ali.
N. Ali. Learned counsel appealing on behalf of
Sole respondent.
on behalf of the sole respondent. Praise for how much time?
4 weeks time.
4 weeks. 4 weeks time to file objections. Praise allowed. Up to 4 weeks.
31.
How many days?
1033.
Yes.
Some more time may be granted Lordship to file objection.
Why are you taking so long? From October, you've been
Yes,
given time.
yes, Lordship. Lordship, it is already ready, Lordship, for getting some more time.
Okay, hurt, mister?
May I say this, Your Lordships? May I just say this? Times have been taken, there's no problem. There's a larger issue involved here. I would request that this ground should be, Your Lordship should condemn this delay. Let me hear it let an objection come on the appeal. There is a much larger issue involved. It's a compensatory benefit ultimately I'm coming against. To distinguish an armed force based on the fact that I am a competent or a non-competent, and to take away a benefit just because of a procedural
See, there's a delay of 1033 days.
It's all explained.
She wants to
It's all explained, Your Lordship, with all due respect.
explanation letter file her explanation. Hurt, mister?
RB Fukan.
RB Fugan and counsel for the applicant. MSR Devil and CGC.
That's
Praise for another.
Lordship,
How many days?
2 weeks.
Praise for another 2 weeks time. Praise allowed as a last chance.
Grateful.
List of the 2 weeks.
Obliged.
32.
Grateful.
He does.
No, delay continuation petition is before your lordships.
Lordship,
delay
delay
of-
continuation petition is not served on us, Lordship. Only serve the review petition, Lordship.
I'll serve, my lord, not a problem. I'll serve.
And delays, I have seen the.
1462 days, my lord. The writ appeal is more or like a mercy petition before your lordships. Because writ petition was dismissed, then writ appeal was dismissed. Writ petition was dismissed on the pretext during the pendency of a criminal proceeding. And in the criminal proceeding, ultimately, the petitioner, he got acquittal. The charge of rape was not proved, and he got acquittal. Then he filed a writ appeal before this honorable court, and this honorable court, my lord, dismissed the writ appeal. The issue is that, my lord, the disciplinary authority, while imposing the penalty, major penalty, also accepted the fact that the rape was not proved, and he was given the major penalty on the ground that he, my lord, he engaged a minor as a maid in his house. So on that ground, my lord, the penalty was imposed, not on the count that because appellate authority after the acquittal, not on the count that the rape was committed, but ultimately writ appeal was dismissed, and the reason for coming late is that, my lord, he is suffering from, my lord, TB in his bone, my lord. So he is in need of some financial. If anything can be done with regard to quantum of penalty, that's only, my lord.
You finish a copy?
I'll furnish a copy, sir.
But Mr. H.K. Das, letter counsel for the applicant. By this application, applicant is praying for 1462 days delay. in
Adi
filing
adi
the
adi, हाँ,
connected
बताओ।
appeal. MS RB Bora. Learned counsel,
Junior Government Advocate, Assam.
learned junior government advocate,
For all, right?
appearing on behalf of all the opposite parties. Praise for how much time you want?
Lordship, let them file the copy of IA. I
Finish
shall
a
file,
copy.
I'll file.
I shall file objection on that IA.
During
No,
the
that's why
course
I'm
of-
saying, how much time do you require?
If you serve me today itself, I shall take 3 weeks time, Lordship.
Fine,
If you will
Praise-
not
I
serve
undertake.
today,
I'll,
Two
today
weeks,
itself.
2 weeks time to file objections. List of the 2 weeks.
I'll.
You finish your copy, Mr. Das.
Yes, my lord.
Today
So
itself.
during the course of the day, I'll furnish.
Timing item 15.
May it please your lordship. May it please your lordship. Lordship, this appeal has been prepared by a society, lordship, Anjumane Khadimul Islam and another lordship. This society, lordship, managing the Muslim properties, Qabrstans and all these, lordship, is a registered society, and the properties were
Lordship registered under the Waqf Act, Lordship. So our claim is that these properties are Waqf property, Lordship. The present respondent number 1 to 4, their predecessor, Lordship, when started disturbing in a shrine, Lordship. So we filed a title suit. That title suit was dismissed. Thereafter, Lordship, board filed a title suit. That was also dismissed, Lordship. But the predecessor of the respondent number 1 to 4 filed a title suit claiming right title interest and without impleading board as well as the appellant's, Lordship. Only impleading Government of Assam as a respondent, Lordship. That suit was decreed, and taking the benefit of that decree, Lordship, they have started execution, and thereafter Deputy Commissioner directed the settlement officer to record the name of the predecessor of the respondents over half a bigha of land, which is a Lordship shrine, in fact, which is situated within the entire Muslim Qabristan of Gwalpara district, Lordship. So accordingly, Lordship, records were corrected. A separate dag and patta was formatted, Lordship. Thereafter, we challenged that, Lordship, before the Revenue Board. And after 2-3 round of litigations, the present impugn order from the Revenue Board came. It states that it is not a Waqf property and it is not a private property of the respondent. So they directed to Lordship register the name of the private respondent and pray for allotment of the land from the Deputy Commissioner. And we were directed to register our name in the Waqf state, Lordship. So 2 directions were there by the Revenue Board, Lordship. That was challenged by the respondents, predecessor of the respondent, by filing the WPC, Lordship. That is the single bench decision in that. And during the pendency of the writ petition, the predecessor died. Private respondent 1 to 4 were substituted. And thereafter, Lordship, the impugn judgment came. The impugn judgment came, Lordship, it says, page, Lordship, 141, the impugn judgment. Relevant portion, Lordship, 146. Para 10, Lordship. From a perusal of the materials on record, it appears that the land covered by dag number 116 is a government land. The dispute in question is in reference to a plot of land measuring 2 katha 10 lesa in dag number 116. The competent civil court had in the judgment and decree dated 31/3/1981 in title suit number 176/1978 held that the predecessor in interest of the petitioners, who was the plaintiff in the said suit, had right title and interest and possession over the land specifically described in Schedule A to the decree, and the said land has also been declared to be a property of Dargah. The state of Assam was also permanently restrained from interfering into the plaintiff's possession over the Dargah land. The said judgment and decree had attained finality in view of no challenge being made by the state of Assam or being set aside in any other proceedings collateral. It is also seen that on the basis of the said judgment and decree, the Deputy Commissioner acted upon it, and thereupon the settlement officer by an order dated 13/9/1991 created a new dag being numbered 227 out of dag number 116 and issued the Khatian number 127 in favor of the predecessor in interest of the petitioners of the land measuring 2 katha 10 lesser. Under such circumstances, the learned Assam Board of Revenue was bound by the declaration of the right title in interest along with the possession in favor of the predecessor in interest of the petitioner. However, a perusal of the impugned judgment reveals that the learned Assam Board of Revenue, holding inter alia that the civil court's judgment and decree was not binding, cancelled the Khatian issued in favor of the predecessor in interest of the petitioners and passed appropriate directions for allotment of the said land in favor of the predecessor in interest of the petitioners by the impugned judgment. In the opinion of this court, the impugned judgment is contrary to the well-settled principle of land that the civil court's decree is binding upon the revenue courts. So, Lordship, I am challenging this portion as because, Lordship, at that relevant point of time, there was a notification from the government of Assam not to act upon any civil court's decision, Lordship.
Oh.
There was a notification, Lordship, that I have annexed along with this page 2934, Lordship. Page 2934. And this is a lordship work-off plan. It is admitted by the predecessor of the respondents in a letter that also I have annexed, lordship. Annexure 2, page 29. This is a typed copy of the relevant portion, lordship.
Page
29 and 30. As because lordship, the revenue correction is the complete area of revenue authorities, lordship. And revenue board is the competent authority, lordship. So we have not challenged the civil court's direction. In fact, lordship, we are objecting before the ADC and DC and the revenue board also.
Opinion, my.
Page 30 also says, lordship, 154 1C of the Assam Land Revenue Regulation also bars jurisdiction. And lordship will find in annexure 5, page 38. Annexure 5, page 38, it shows the Chief Executive Officer of Assam Board of Waqf's lordship write a letter to the President of Anjuman Khademul Islam. It's a lordship, very recent document, 11/10/2022, lordship.
Page 38.
38, lordship, annexure 5. With reference to the subject cited above, I am to inform you that Ikramul Hussain, Auditor, Assam Board of Waqfs, will be visiting Waqf estates in the district of Gwalpara from 19/10/2022 to 30/10/2022. Carry out the audit on the accounts of the income and expenditure of the following Waqf estates under the management of Anjuman Khademul Islam. Muslim Qabristan Waqf State, registration number 113. And the next page 39, your lordship will find. This is the predecessor of the present respondent number 124. He is Mohiuddin. This is a letter from that person, lordship, to the chairman, Assam Waqf Board, this board. I beg to inform you that I am the president of Old Islampur Samaj. There are 4 Qabristan at Gwalpara. In the revenue records, they were recorded as Muslim graveyard. But in the present survey, the Anjuman Khademul Islam has got 3 of said Qabristan recorded in its name, such as Anjuman Khademul Islam Qabristan, Muslim Qabristan, belongs to all Muslims. It is a Waqf property. A particular institution has no right to get it recorded in its own name. So he admitted that it is a Waqf property, lordship. And when the writ petition was pending, lordship, an order was passed, lordship, calling the revenue entire record as well as, lordship, the respondents, that is the present appellants, were given chance to file additional affidavit to bring on record these documents, lordship, on 8/10/2023.
You have to issue notice
Lordship.
on this.
Waqf board is also the party here.
That is up to the person.
In writ petition, they were not heard.
Ms. R. Chaudhary and counsel
Archer.
for the appellants. Appellant to take steps for service of notice on respondents 1 to 4
1 to 4, lordship.
by registered post ID 1 week from today. Bharat. Mr. Endas.
Yes, my lord, 6, 7, 8.
You are for 5. MSN Bordole, Learned Standing Council Revenue Department appears for respond number 5. And Endas, Learned Additional Senior Government.
Government.
Government advocate for the
6, 7, 8.
6, 7, and 8. List after 4 weeks.
And deeply
Record to level.